A very good morning to all my dear students. I welcome you all for today's class on Indian Partnership Act. We have started Chapter 2, Relationship of Partners, and we'll try to finish at least 90% of the chapter today by itself. A very good morning, Pavan Kumar. Good morning. Deyansh, Anil, Kusha, Anushka, Naina Verma, Ansupam, Piyush. Good morning, children. Okay, Ibrahim says, I have a query. That's wonderful. That means you have a query generally when you have studied well. So that's great. Good morning, Palk Bhardwaj, and all the children with us on the portal. Students, I hope you all have revised whatever we have done in the previous lecture. Yes? All right. Good morning, Shubham, Abdul, Ria. So we have good number of students today. Kush, good morning. Let me see all the students over here with us on the portal as well. So students, we have already done chapter number 1 and chapter number 2 we have already started. Can anyone quickly tell me out of the revision, what do we understand in chapter number 2? That is when we talk about Vedant Gupta, Jaimil Reshi, all of you. Good morning, children over here also. Okay, Vedant Gupta, good morning. So what does this chapter basically tells us about? What is relationship of partners? What are we actually trying to cover in this chapter? Who is going to tell me? Meanwhile, I'll read the query given by Ibrahim. I have a query related to types of partners. Nominal partner is not entitled, but he essential consists one of the point of agreement must to be shown. Okay, Ibrahim, I have read your query. I'll just answer it in a while. And all those who have answers, ma'am, this chapter tells us about how we mutually run the business, rights and duties of a partner, general duties, excellent. So this is what the whole chapter is all about. How we are related among each other, how the partners have a responsibility towards another partner and how they are related to the outside world. That is where this whole chapter revolves around. So we have already discussed the previous class, the general duties of the partners, the rights of the partners. Today we'll be starting how they are dependent on each other. So these all the rights were discussed. We have also spoken about partnership property, but as a thumb rule, we always revise whatever we have done in the previous class and then we move forward. So here is a quick question for revision for all of you. What is the meaning of partnership property? So we have understood the partnership property means the capital brought in by the partner and all the assets acquired during the course of business. But if I tell you that the property of the firm is located in Pune and most of the partners of the firm keep traveling to Delhi in Southex in Delhi, there's a place known as Southex, and they have fixed a place of meetings over in that place. So can we say this property in the Southex in Delhi is also the property of the firm? Can you tell me, can you apply the principle of section 15 and tell me whether this property where all the partners are meeting, just for having a meeting, does it becomes the partnership property? Yes, Pavan Kumar. Excellent answer given by Pavan, Divyansh, Anil. No, ma'am, it will not become the partnership property just because we are having a meeting there. No, because it does not belong. It does not belong to the firm. Excellent answers because they didn't identify it. So in order to convert it to a partnership property, we need to have an agreement that yes, we have purchased it for the purpose of business. We are going to conduct our business meetings and any other kind of business in that property, then it will become a partnership property. But any restaurant, any cafes, any outings, anybody's house of the partner is not partnership property just because you are doing your meetings and conducting business at that place. It will not automatically make it your partnership property. Is that clear, children? Okay, Ibrahim, your question that you have asked about nominal partner. So nominal partner is one who lends his name to the firm. Okay, so since he is lending his name, it is because of his reputation the firm is getting business. He is a partner who is allowed to be a part of the partnership by just signing with his name. His identity, his identification is enough for the firm to get the business. That is why he is not interested in sharing the profits. He is a partner whom by law under Indian Partnership Act, it has been given the identity that you can be a partner by lending your name, but it is not necessary for you to participate in the conduct of business. However, your liability remains towards the outsider. So what was the reason why nominal partner was held liable? The question of Ibrahim is, ma'am, why he's not sharing the profits? If he makes an agreement that yes, I want the profits also, then he can get that also. But as per law, there is no requirement for the nominal partner to get the profits. All right. So why does the nominal partner remains liable to outsiders? Can anyone answer me? Yes, Umang is asking, ma'am, facts of the case is compulsory to write in the answers. Definitely, beta. Facts of the case, the relevant provisions, facts of the case, and conclusion. This is the proper way of writing the answers. Khush, good answer. Co-ownership is also not a partnership. Just because he lends his name and guarantee the firms. Pavan Kumar, very good. Because he's lending his name, the nominal partner. The question I've asked you, I repeat the question. I'm just getting 2-3 answers. What about others? Early morning, you cannot sleep in the class, children. You all have to answer me hurriedly. The nominal partner, why he's liable to the outsiders who are dealing with the firm? Because it is of his reputation, it is of his name the firm is getting the business. People know him that he's a partner. Sleeping partner was not required to give a public notice because people don't know him. But although his liability was unlimited because firm, he's doing the business with the firm. Firm knows about his identity. But he was not known to the outsiders. This nominal partner is very well known to the outsiders. I know that Shah Rukh Khan is a partner in your firm. He's a nominal partner. That's why I'm giving a lot of business to you. Your firm must be really doing well. That's why such a big celebrity has lent his name. All right. So I hope everybody is clarified on the point of nominal partner. Any other doubts you have from this chapter number 1, please, children, you can feel free to ask. Okay, Ibrahim says thank you. So welcome, Ibrahim. I'm glad you have understood. Anybody else has any doubts, please ask. All right. So partnership property also we have revised. We have revised nominal partner also. Now, what was section 16 about? Section 16 was about the personal profits earned by a partner. Let me again give you a question for test. There are 3 partners, A, B, and C in a firm. Mr. A buys, they are into sale and purchase of rice. Mr. A buys rice from the market worth rupees 10,000. And he goes and sells it to the firm. He tells them that I have purchased it for rupees 20,000. Firm, please give me 20,000 from the firm's mutual fund, the joint funds that we have. I'm taking 20,000 out from that box, from that money, because I have purchased the rice for rupees 20,000. Children, do you think this Mr. A is trying to cheat the firm? 10,000 का राइज आया, आपने ज्वाइंट फंड में से 20,000 उठाया. हाउ मच सीक्रेट प्रॉफिट? सीक्रेट मीन्स छुपा कर, चुपके से, चोरी से. So you have made a cheating you have done with the firm and you have made a profit worth rupees 10,000. But at the same time, if I'm purchasing something for the firm, I purchase it for 10,000 and I spent my own petrol for rupees 1,000. I had to go to a different city and I have to go over there to purchase the rice and I had to come back. So the bill of the petrol was 1,000. If I recover 11,000 from the firm, am I earning any secret profit? Very good. All of you say no, ma'am. Why, children? Because here I'm not recovering anything. I'm not getting anything. Here I'm just recovering the money that I have spent. I'm not doing anything. Additionally, I'm not charging. Are you all clear about this? So if you are charging anything additional from the firm, you are trying to make any secret profits, then the firm can recover those secret profits from you. But if you're just doing any kind of business for the firm itself, then it cannot be recovered from you. Okay, let me just open up the study material also for all of you. I hope you all can see the study material. Is it visible to all of you? So this is the point of your section 16 that it tries to tell you, because each and every point from study material is also equally important. First point we have done, if a partner derives any profit from the firm or uses the property of the firm and he earns any profit, then it is his duty. What is his duty? The 10,000 that you have earned, you should report it back to the firm. Simple. इतना ही करना पड़ेगा. Is liable. Abdul Shah has written A is not allowed to further liable to the pay, but the petrol expenses is called reimbursement. Yes, that is fine as to be compensated. That's absolutely correct, Abdul. Firm needs to compensate him for that 1,000. Okay. Very good. Khush says it is the general duty of partners to be loyal towards other partners. So you remember your duties. You remember the duty to indemnify, the duty to indemnity. Very nice. Business expenses can be claimed. Kavita says that. Thank you, Anuspa, for confirming it's visible. All of you have given wonderful answers. Well done. Sajib, are you trying to say something? I cannot read your question. Only a line is written, incomplete line. You can write it back again. Then second type of partnership. If you are my partners in a business of sale and purchase of shoes, but personally I'm sitting at home and I'm also teaching my students. So I'm into sale and purchase of business with my partners in sale and purchase of shoes. Also, in my free time, I love to teach my students and I'm getting certain income from my students whom I'm teaching. Am I doing any competitive business which is competitive to the nature of the business? I'm not using the firm's name. I'm not using the goodwill that is built on the basis of partnership. I'm teaching as a sole proprietor, as an individual. Or maybe I'm running my own shop wherein it's my father's business. I also sit over there and contribute, which has nothing to do with the sale and purchase of shoe business that I'm doing with my partnership business. Then there is nothing about secret profits or personal profits. You're not cheating. And also you have signed an agreement to the effect of that. Please, children, this line is very important. Subject to contract between the partners. I, as a partner, signed a contract with you that I will not be doing anything against our own partnership business, but individually I'm doing this. I'm open about it. So that means you're not hiding anything. You're not cheating. Then you're not earning any secret profits. Then you're not required to give the profits that you have earned to the partnership business. All right. It is the duty. No, ma'am, it is, yes, the business are totally different. Then you are not doing any competitive business. But if at the same time, I have also kept certain stock of the shoes, which I'm doing with my partnership business, the same competition with my own firm, I will be held liable and I need to pay back all the profits to the firm. Again, this rule is subject to contract between the partners. So I've already explained you why we are doing while we have done a contract, then it's allowed. Yes, Sajib, you want to ask something?
पार्टनरशिप बाय होल्डिंग बना दिया और एज लॉ में लिखा है कि पार्टनरशिप डेट कंपलसरी नहीं है। जो अगर राइटिंग में लिखो तो ठीक है, वरना ऑरली भी चलता है। तो हम अगर किसी को बस मुंह जबानी किसी को पार्टनर बना दिया और उसके साथ रेगुलर कोर्स ऑफ बिजनेस चलता रहा, उसको हम ऐसे
Okay, let me just correct you on one point, Sajib. You said that we just told anyone and anyone became a partner. It's not the case. You have to read the law in complete sense. It was written that I allowed Mr. A to be a partner in my firm, and the dealer, on the faith of this understanding that A is a partner, has given certain credit to the firm. ऐसा कुछ हुआ होना चाहिए कि आपके पार्टनर घोषित करने पर फर्म को क्रेडिट सप्लाई हुआ एंड फर्म ने उस चीज की पेमेंट करनी। Now a firm has to pay money for that transaction. For that particular transaction, Mr. A will be held out as a partner, not for any other acts of the firm.
ओके, तो ये ऐसे नहीं हो सकता क्या कि हम मतलब हम किसी के थर्ड पर्सन को पार्टनर घोषित कर दिए और इसके बाद मतलब ये किसी बंदे से क्रेडिट नहीं ले रहा है, बट हमारे ब्याह
पे then he is not declared as a partner by holding.
तो पार्टनरशिप डीड पे उसका नाम लिखना ही पड़ेगा क्या?
Yes, then only you become a partner. Partner by holding out is specifically for that transaction where I'm introducing you as a partner and the other party has relied on that judgment. If somebody just came to my firm, I said this Ch4 in my firm is also a partner and he did not do anything and no business was given to me, then he does not become a partner just because I said that. Okay? Transaction should have happened.
Okay.
All right. So section 17 also, children, we have done that any change in the constitution of the firm. What were the 4 cases where the constitution of the firm changes? Quickly write it down in the chat box. It's your revision going on. It's your test. You have to tell me what are the 4 cases. Change in the partners, admission of a partner, particular partnership, fixed partnership, admission, retirement. Excellent. Deyansh Bharti. Deyansh Bhatti, Pavan Kumar, Kush, Anushka, all of you, very nice. Priyanshi, Naina Verma, all of you remember. So what happens in whenever this change in name and other things of partnership happen, then the rights and duties of the reconstituted firm remain the same as if they were before the change. So whatever rights and duties were given to us, they will not undergo a change. In fact, a new partner has joined, he will also get the similar rights and duties. If the firm's time period has expired and you still feel like continuing the firm as a partner, then what does that partnership becomes? Divyansh has already written good. Then it becomes partnership at will. Very good. And if the particular partnership means the partnership that you have undertaken for a particular venture, that also ends and you still continue, it becomes partnership at will. Everyone is crystal clear till section 17, children. Now let's move to section 18. Again, section 18, a mere introduction was given to you in the previous class, which simply tries to tell you about the mutual agency relationship. You are a partner, I am a partner in a firm, Divyansh, Harleen, Piyush. These 3 are partners in a firm. Whatever actions were taken by Piyush for the purpose of business, Divyansh and Harleen will be liable. Whatever actions Harleen has taken for the purpose of business, Divyansh and Piyush will also be held liable because all of them are acting as a principal as well as agent of the firm, provided they should be doing the acts for the purpose of the business. If we are into shoe business and Divyansh went to the market to purchase rice and kept it at his home, is Piyush liable as a partner to pay for this rice? Why do you say no, ma'am? Because, ma'am, it is not in the course of business. It is a personal thing that you have purchased. And also the second thing that you have written is you have kept it at your house. Okay. At the same time, if I'm buying, if Piyush goes to the market to buy certain, stuff for eating for the meetings to be held in the firm's business. So he went, he bought certain samosas, kachoris, gulab jamuns, and there's dhoklas, and there's going to be a grand party at the partnership office. Now, can you say that the firm can also be held liable because you're eating it, you have ordered the food for the firm, for the own purpose of the business you're having the meeting? Then yes, other partners can be held liable, provided there is a contract to the contrary. Contract to the contrary can be Piyush said that it's my birthday, I'm going to treat you. Then he will only pay. But maybe if some organization has held a party for certain clients or something and they have ordered these kind of things, then yes, if it is for the purpose of business, what is the underlining line that you have to mention to the examiner? If it is in the ordinary course of business, if it is in the nature of the business, then firm will be liable subject to the contract of contrary means if we have agreed something else, then that thing as per the agreement shall happen. Ranchit Sharma, these kind of admin queries are not to be addressed over here. How many holidays will be given? How will we study the subject? It is not to be addressed over here, child. This is something which you can directly speak to ICAI. And secondly, if you talk about studying the subject, then yes, if you are attending the lectures well, you are revising the content well, then don't worry about the holidays. You will definitely be able to do it with good marks if you're studying today for the subject. Don't wait for the last day, okay? All right. Now, what is the meaning of implied authority of a partner? So one, we have understood that the partners are the agent. Everyone is clear on section 18. What does section 19 to 22 tries to tell you? that there is an implied authority of the partner. Can you tell me what is the meaning of expressed and implied authority? What is the meaning of the word authority? You must have been a BCom first year student. You must have studied Principles of Management. PPM is a subject which is in BCom first semester. In that, when you do these 14 Fayol's principles, the first thing that you talk about, and even in business studies, when you learn about the word authority, what is the meaning of authority? Authority goes with responsibility and accountability. Remember? Have you heard about this word? Authority? Yes. You have to speak. मुझसे ज़्यादा बुलवाते हो. You have to answer me back. Yes, a governing body. Piyush is saying it's a governing body. Express or written means by actions. Yes. So you know about the authority. Authority can be expressed or implied. Anil, that is a separate story. First, I'm trying to understand what is the authority. Authority means power. You have the power to do. What power you have the power to do? Yes, Anuspa, now you're writing right. Satyam Dubey. Authority means power. Very good. So मेरे पास अगर मैं sale and purchase of shoe में हूँ, so I have the authority to buy the shoes. I have the authority to sell the shoes. I have the authority to fix the margins of the profits to be gained. I have the authority to pay the electricity bills for the firm. These are my authority. This is my power. Now, it can be either expressed or implied. Now, Anil's answer is correct. Expressed, Abdullah also given the correct answer. Expressed means written or oral. Implied means something which is implied from your actions. So you all went to Starbucks to order a cup of coffee. You just lifted the menu and you just pointed out like this. You did not speak, but you pointed out at the Java choco chip. You had the coffee and you went out of the showroom. Not showroom, cafe. Are you bound to make the payment to that Starbucks guy? Or you just drank the coffee and went off? A child will say, ma'am, I did not make any express contract. Why am I liable to pay? It's binding. Very good, Divyansh. Why? Because it was an implied contract. You did not speak, but your actions, when you pick up the menu, you showed him, he got the coffee for you. That is an implied action. So never forget the meaning of the word implied. Implied means जो आपके actions के साथ contract form. Express means when you have spoken the words, yes, please get me a cup of coffee, and he ordered you, you have placed the order, he serves you, you have to make the bill payment. That is an express contract. But the moment that we did just now, right, by showing you the actions is an express contract. So the authority can either be expressed or it can be implied. Authority means capacity of the partners to bind the others by his action. Now, whatever act, suppose we are in the shoe business, so A goes and make the purchases of the shoes. Whole of the firm is liable for this because it is in the act of business. But if ABC is the firm and A books tickets through a travel agent for a holiday, then only A is liable to the travel agent. Whole of the firm is not liable. Why? Because this is the act done for his personal purposes. But if he would have booked the tickets for the business purposes, then yes, firm would have been held liable. Now, express authority means by word spoken or it is written in the partnership deed that only you can. Yes, coolie taking bags, we are liable. Kusha, that is the tacit contracts. Excellent. All of you, Ansupa, Kush, Divyansh, have mentioned it correctly. Abdul Shah, it is an implied contract. Good. So all these things where you are doing an action is an implied contract means by your actions you become the acts become binding. So it is in the normal course of business if you're doing something or in the acting in the usual way of carrying the business, you bind the firm. So it is the same example. The normal business is to sell and purchase the clothes instead of shoes, but does that has the authority to do such an act? So the answer is no, because the partner can only do the acts related to the business. Firm is not bound by such act. So if you are into shoe business, you're buying clothes, firm will not be liable for that. Is that clear? Express authority is by word spoken, implied is with your actions. With both the authorities, you bind the firm. Now, why it was important to understand these kind of authorities? Because once you have entered into a partnership, you have signed a partnership deed or agreement. That means everybody is free to do the business in the firm. It is an implied authority. One will go and purchase the firm, goods for the firm, sell the firm. Anyone can do any business, any kind of activities to run that business. But statutory restrictions means law में legally कुछ restrictions लगा दी गई हैं partners की powers के ऊपर. Means whatever implied authority is not defined. Anything with your actions, you're binding the firm. I'm into partnership. I just went outside. I ordered 3 glasses of juice from the vendor and I took it to my firm, and that vendor came running and he said, Mr. BNC, your partner Herleen has ordered the juice. She has not made the payment. So is it an implied authority? You cannot say that anything I will do for the firm, I will bind the firm. There have to be certain norms and conditions to be followed, right? You don't have to misuse your power because you are a partner in it. So yes, the vendor can still charge from any one of you because he just said that we need it for the firm. So if the word for the firm has been used, that means firm becomes liable. So all these actions have to be taken control. It should be very much clear in your partnership deed what authority is binding and what authority is not binding. So it says partners can do the following acts unless agreed. Now there are 7 to 8 restrictions which have been put on the implied authority. It says here, right now you went to buy the juice, okay, you made the firm liable, that's fine, but law has imposed 8 points of restriction. That means you cannot do these acts. Partners ये सब चीजें नहीं कर सकते. Restriction का मतलब होता है these 8 things cannot be done by a partner. Underline word unless agreed in the partnership deed. Flexibility of partnership. Anything we want to do, we'll make an agreement and we'll do. But if the agreement is silent on these 8 points, then law says that these 8 points cannot be done. Kavita, if you have query related to past one, I can allow you, but this topic I am yet to explain. So you have a query on the same, or what do you want to ask? Yes, Kavita. Okay, you have raised your hand, Kavita. You want to say something, or by mistake you have raised your hand? All right.
Hello.
So yes, Kavita.
I'm audible, ma'am.
Yes, now you're audible.
Okay, ma'am. ABC were partner and we purchased some in carrying on business of clothes, selling clothes. We purchased some clothes on behalf of business only, okay, and wanted to sell from business, okay, but A and C were denied that purchases. They can deny or not.
So they are into sale and purchase of clothes only.
Okay. Huh.
So he has purchased it for the purpose of business. Am I right?
Without intimating A and C. But he is in good faith purchase that for sale only on behalf of business. But A and C afterward denied that purchases.
So they did not agree. Okay. So mute yourself, Kavita. I'll give you 2 answers for this. Kavita, this topic specifically relates to your topic of Unit 3, that is dissolution of firm, where the partners are not agreeing with each other. They are not giving a consent. The firm might get dissolved. There can be various reasons for that, which we'll be covering in Unit 3. If you talk about the authority that the partners have used and they're trying to bind the firm, again, there will be 2 solutions. If you have purchased it within your limits, with the consent of other partners, whole of the firm is held liable. What are the reasons behind denying of Mr. A and C? If they are denying it just because they don't like Mr. A, they don't want to work with him, they're not happy with his purchases, then your Unit 3 will become applicable. All right, I hope it's clear now. All right, so there are 8 statutory restrictions on the implied authority of the partners. Submit a dispute for arbitration. What is the meaning of the word arbitration? So one is, if we have any disagreements, we can go to the court. Like the Kavita gave the example, A and C are not agreeing, B and C are not agreeing. A can go to the court. That see, I made these purchases and they're not agreeing to pay. So that is in Unit 3, he can file a dissolution for the firm also. He can demand that I want to get separate with them because they're not listening to me. or they can make an agreement how these things can be sorted out. But submit, so whenever the partners have any problem, they can go to the court. Ranchit, again, you're writing the same query. I have to attend my college. Then you have to take help from the ICAI. I cannot comment anything on that. Okay. So if you are filing a suit for dissolution, means if you're going to the court for the court proceedings, you can go to the court if you're a partner. But arbitrators are somebody that they tell you that instead of going all to the court, you can just go to these arbitrators who listen to both the parties. They will make both the parties, aggrieved party and plaintiff, sit with them. They listen to their both sides of stories and try to give a resolution to their problems. But can the partners go to the arbitrators for their disputes? Disputes means fight, ladai jhagda. Can a partner go to the arbitrator? Law says no, it is not allowed. As per section 19 to section 22, the restrictions on the implied authority says that the partners cannot submit a dispute, means they cannot file case or fight with the arbitrator. Means if they have any problem, they just have to go to the court. Okay. So like advocates decide, yes, Divyansh, legal advocates decide appointed by the court is also arbitration. Instead of outside the court, whatever resolutions you're doing is known as arbitrate. So partners cannot go to the arbitrators. They always have to go to the court. It is not allowed. Opening a bank account on behalf of the firm in his personal name. Now you are a firm ABC Associates and you open the bank accounts in the name of firm ABC Associates, that is fine. But the firm's business bank and you have opened it in the name of Mr. A or Mr. A's son, Mr. M, you have opened the bank account in his name, then that is not allowed. Law has imposed a restriction that you cannot say that we have implied authority, we can do whatever we want, but these 8 things you are not allowed. All right. Compromise or relinquish any claim. First 2 points are clear. Arbitrator के पास नहीं जा सकते in Hindi, and second in Hindi is banking account आप अपने नाम पे नहीं खुलवा सकते बैंक account. Firm का है तो firm के नाम पे खुले. Compromise or relinquish any claim by the firm. Compromise means you're giving up. Relinquish again means to give up. So the firm was liable to pay 50,000 rupees to Mr. D. Firm did not pay. Case was filed by Mr. D and now we are having proceedings against the firm are being held. Mr. A just got up and said, Judge Sahab, I compromise on this claim. Okay, compromise any claim by the firm. Claim was to be taken. All right. Wait. 5th point is admit any liability. Compromising any claim by the firm means D had to pay 50,000 to the firm. And this Mr. A, being the relative of supplier D, he goes and tells the court that, okay, fine, we give up on this claim. We don't need it. It's not required. We don't want this 50,000 rupees. Firm is allowing Mr. D to leave this 50,000 rupees. So law says you're not allowed to do that. If there is a court proceedings going on, you cannot just go and relinquish any claim. You have to fight for it. You have to give the valid reasons. You cannot just say admit any liability. 5th point, ye bhi isse related hai. You had to pay 50,000 rupees. And you said that yes, firm, yes, court, we are ready to pay the firm, Mr. D, rupees 50,000. So you cannot go and admit any liability for the proceedings against the firm. You cannot compromise any claim means अगर कोई पैसा आने वाला है, आपने उसको forego कर दिया, या फिर कोई payment जाने वाली है, आप अपने behalf पे you are just going and saying that yes, we are agreeing to pay that. You have to fight a case for that. Proceedings means case that is going against the firm. So point number 3 says you cannot give up any claim. In Hindi, you can write down, in simple language, you can write down, you cannot give up any claim by the firm. 5th point says you cannot accept any liability against the firm on your own. You cannot accept any liability on your own. But you have to learn this terminology, which is written over there. Legal words have to be learned. 6 marks question, if it comes straight away, what are the statutory restrictions? It is such a creamy question. You have to learn this and just write it the same language as it is and you get 6 out of 6. What is the harm? You have the time of the universe with you in your pocket, children. Sit and start studying. पढ़ाई जो करता है वो कभी फेल नहीं होता है. Mark my words. But अगर कोई बोले कि I just opened up for 2 hours my book for law and then I thought that I'll open it after a week's time, or I'm just reading the chapters, I'm not learning it, I'm not writing it, I'm not revising it, then things become very difficult and you are cheating with yourself. So don't cheat. Stop cheating with yourself. Make a proper timetable. Studying means properly writing notes and making your everything ready for revising, learning. Learning has to be done in law. There is no escape route from learning. If the words compromise or relinquish any claim by the firm has been understood, you have written it at the topic, near the topic, that giving up the claim, that means you know the meaning. So now learning part is only. So you have to learn these words. Admit any liability means मैंने किसी liability को accept कर दिया firm के against. Now I simply have to learn is admit any liability in a suit or proceedings against the firm. Suit or proceedings is one and the same thing. Or fourth point, withdraw a suit or proceedings filed by the firm. So firm has filed a case against Mr. G, a supplier, and this Mr. A goes and he said that I want to withdraw it. You as an individual partner, you don't have the authority to interfere with firm's decision. You cannot go and withdraw. Withdraw means मना कराना. ठीक है, हम take off कर रहे हैं. We don't want. We are giving up on this case. We don't want to do any case against Mr. G. You cannot do that. It's firm's decision, unanimous decision of the partners to file a case. You don't have the implied authority to withdraw a suit, to compromise any claim, or to admit any liability against the firm. So 3, 4, 5 are all related points. First and second are individual points. First is related to you cannot go to the arbitrator. Second, you cannot have bank accounts in your own name. Third is liability. मना नहीं करनी. जो कोई claim आने वाला है वो मना नहीं करना है, compromise नहीं करना है. Fourth is suit या proceedings को withdraw नहीं करना है. Fifth is you don't have to accept any liability on behalf of the firm. Then sixth and seventh point are again interrelated. You cannot acquire any immovable property on firm's behalf. You cannot go and say that I've purchased a land and building and it is on behalf of ABC Associates. You cannot. A firm can acquire it on its own behalf, but yes, subject to a contract unless agreed in the partnership agreement. If we have made an agreement that, okay, Mr. A will go and purchase the property for us in Delhi, which we'll be using as partnership property, then he can go and purchase the partnership property. But otherwise, you cannot acquire any immovable property on firm's name. You cannot sell. Transfer means sell karna. Acquire means purchase karna. Transfer means to sell. You cannot even sell any immovable property which is belonging to the firm. You thought, okay, we have a office in Pune. I'm going to transfer it. I'm going to sell it. You cannot do that unless there is an agreement between other parties. Sixth and seventh are also related. Immovable property points, simple. Arbitrator done. Bank account done. 3 points related to liabilities and case filing. 2 points related to immovable property. And the last point is very, very important. You cannot enter into partnership on behalf of the firm. Firm can never be a partner in another firm. So ABC Associates are having 3 partners, A, B, and C. So Mr. A can be a partner in another firm. But ABC Associates cannot. Say, for example, Mr. A is partner in PQR Associates also. Can ABC Associates be a partner in PQR? Tell me. क्या एक firm partner हो सकती है? Can a firm become a partner? Company can become a partner because company is a legal person. Can a firm become a partner in another firm? Very good. Yes, Pawan Kumar, you have to use that line unless there is a contract to the contrary. Very good. Sonam Rajwat is asking how to make notes. So whenever you're studying, whatever briefing you are getting, you should try to make it small notes. Otherwise, you can just in your study material only, you can mark the things in points, writing practice, and then learn. Very good. Only the person can become a partner. Anushka and Anil, very good answers. No, ma'am, because firm is not a legal person. Therefore, firm cannot become a partner in another firm. Is that clear, children? Let me see the students on the portal also with us. Sometimes they just get ignored because we are just paying attention over here only. Yes, Mr. Sajib Das, your queries are coming here. I hope everything is now answered. Yes, Aniket, you will get all these notes. Vishwas, good morning. Ms. Kaushal, good morning. Vedant Gupta, unless contract to the contrary is really important. Excellent, Mr. Vedant Gupta. So if we have made any agreement, then the statutory restrictions can also be go away. But otherwise, law has imposed a restriction on all these points. Where the partner is holding out. Okay. Okay, so we have few students over there also. You can address your queries even if you have any queries, okay? Firm is not liable, right? Nena, Kavita, all of your points are clear. Everybody is clear. Any doubts and restrictions on implied authority of part? Everyone is clear about section 19. Now let's move to section number 20. So 19, 20, 21, 22 are all given together in your one paragraph in your study material. Section number 20 tells you extension or restriction on partners' implied authority. So now, since you have understood the term implied authority means whatever we have entered into a partnership agreement, either the terms can be in writing and certain things which are not to be written. Again, the meaning of implied in partnership business is, say, for example, we were into purchase and sale of shoes. All right. So, express means by words spoken and written, implied means with your actions. So do I need ABC or partners, do we need to tell Mr. A that you are required to purchase the shoes or you're required to sell the shoes? He's not required to be told about this thing. It is implied. ये तो पता ही है कि हमें ये काम करना है. So we have 5 dealers, PQRST. So A can go and buy from any of the dealers. We have not told him anything. We have not expressed it. So it is implied that you can buy from any of the dealers. Is that correct? But now law is trying to tell you section 20, where we try to put certain restrictions on their implied authority. One is that section 19, law has imposed restriction. Here in section 20, you all the partners ABC by mutual agreement are either extending the implied authority. Say for example, earlier Mr. A was allowed to buy only for 50,000 purchases. Now we said, okay, fine, you can buy up till rupees 1 lakh. Or you are restricting his implied authority. Earlier, he was supposed to buy for rupees 1 lakh. Now you said that you cannot buy for more than rupees 50,000. Either you are extending his authority, you are giving his permission to do it beyond his authority, or you are putting a restriction on his implied authority. Partners by mutual agreement means as per their own agreements and arrangements, they can either extend or restrict the implied authority. Now, what is important over here is third party. Third party means the people who are dealing with the firm, the creditors, suppliers, bankers, whom the firm has to make the payment. They will not be bound by such restrictions if they don't know about it. Means, say, for example, ABC Associates are a firm, 3 partners. A has been told that you cannot make the purchases from Harleen ma'am. They have put a restriction. But I am the third party supplier. But A came and made the purchases from me. So it says third party is not bound means I will go and recover my money from the firm. I will tell them that I never knew that A is not allowed to make the purchases. It is your duty to tell me. I have been your dealer. Now you have stopped A from making purchases from me. I never knew about this restriction. Therefore, I am not bound means firm will have to make me payment of rupees 10,000 for whatever purchases the firm has made. Let's read the example. ABC are partners selling furniture. A agreed not to buy furniture of more than 10,000. What is the meaning of this line? A agreed not to buy the furniture of more than 10,000 means have we restricted or have we extended the implied authority of Mr. A? Are we restricting or are we extending implied authority of Mr. A? Quickly, everyone. Yes, ma'am, we have put a restriction on A's implied authority that you cannot purchase the furniture for more than 10,000. But what did A do? A purchased the furniture for more than 10,000, that is 20,000 from whom? From X. So can we say X is a third party? Yes or not? Hurry up. Can we say X is a third party? ABC are partners. A is a partner who has employed authority has been restricted and there is a third party, Mr. X. So what is the second line written in the principle or the third party? Third party is not aware of this restriction. You can always take the money from the firm. X was not aware, उसको नहीं पता था कि 10,000 की purchases करनी है, उसने 20,000 कर ली. Can X recover the money from the firm? Yes, ma'am or no, ma'am? If he is not aware. Very good. Everyone has given the correct answer. Yes, ma'am. If he's not aware, then he can recover it from the X is not a third party. Who is saying this X is not a third party? Answer by X is a third party. Okay, so he can recover the money from the firm because he was not aware of the restriction. But if X is aware of the restriction that A cannot buy more than 10,000, now comes to your shop, I'm Mr. X. I know that A is not allowed to buy more than 10,000, but I tempted him by showing a heavy furniture of 20,000. And he said, okay, fine, we'll buy it. Now X cannot go and claim it from the firm because he was already aware. He was having knowledge about this thing. So law says, section 20 says, if you're already having knowledge that the partner does not have the implied authority, then you cannot recover that from the firm. You can recover it from Mr. A, but you cannot recover it from the firm. But if you're not aware about the restriction, then you can recover it from the whole of the firm. All right. I hope you have understood till here, children. So section 19, 21, 22, and 20 are very, very important. I give you a break over here. Read section 19 to 22 from the study material also. Think about your doubts and then we'll proceed ahead. Okay. Let's take a small break here. I hope I'm audible now, children. So I hope you have understood all these sections nicely because I could not find any queries. Now let's move to section 23. Okay, one of the query has been received, tells us about the implied authority, but there is only authorities that a partner does not empower by section 19. Kavita, I will just take this point from the study material. Yes, Mr. Divyansh has written a query. ABC buy commodities, sharing the profits equally. Mutual agency will exist or not to disclose. Definitely, you just have to see whether mutual agency is there or not. Then only it becomes a partnership firm. Otherwise, it can be a co-ownership also. But where you're having agreement, you're sharing the business, you're sharing the profits, you're doing the business, then mutual agency will make the firm binding also. All right, Divyansh. And Kavita, I think you are mentioning about the points which are, shall we quote section 19 for the reference of this question? Yes, you can quote section 19, but again, I told you, children, sections are not compulsory to be mentioned. But if you have learned the section well, then there is no problem, but never mention a wrong section. All right, yes, Divyansh wants to speak something. Yes, Divyansh.
मैम उन्होंने क्वेश्चन के जो क्वेश्चन है उसमें उन्होंने आंसर में लिखा है कि यस ही ये पार्टनरशिप फर्म है, परंतु उन्होंने म्यूचुअल एजेंसी के बारे में तो कुछ बताया नहीं.
Which
इसलिए
question?
मैं
Right? That the question given in the co-ownership, the section 4 you're asking?
मैम आई एम आस्किंग द क्वेश्चन दैट आई हैव आस्क्ड इन माय डाउट.
Example
B
one है, ये study
buy.
material का example one है ना ये.
मैम ये आरटीवी का पूछा हुआ क्वेश्चन है. एक ये
Yes, what
क्वेश्चन
do you want to
डाउट
ask in that?
एंड सेकंड आई हैव डाउट इन द
नहीं,
क्वेश्चन
इस
आर.
क्वेश्चन का आपको क्लियर हो गया बेटा? इस क्वेश्चन में आपका डाउट है कि म्यूचुअल एजेंसी नहीं लिखा हुआ है, तो हम लिख सकते हैं. तो मैंने आपको बोला बिल्कुल लिख सकते हैं.
ओके मैम,
Clear?
ये क्वेश्चन का डाउट क्लियर हो गया. मैम एक और क्वेश्चन है जहाँ इन्होंने बोला कि ए बी दे टू फर्म्स ईच हैविंग 12 पार्टनर combined by an agreement into one firm. State whether the following are partnership under Indian Partnership Act 1932.
Please come again. Beta, why don't you write your query in the query pad na, so that I can read it? आप chat box में लिख दो. I will read it and reply back to you because voice is breaking in between.
Okay, ma'am.
Okay. All right. So, yes, in the study material, Kavita, you were asking something. So let me show you. This is what is section 1918 about. This is section 22, and this is how 19 deals with section 22. We are going to read all this from the study also, but section 22 simply tells you that every act done by the partner is binding on others. So it is again repetition of the mutual agency relationship. What are the implied authority of the partners related to? So implied authority of the partner means if we are into sale and purchase of shoe business, then it is my authority, it is my power to purchase the shoes for the business. It is my authority, it is my nobody will come and tell me that switch off the lights. It is my duty. It is my duty to keep the table clean. It is my responsibility. It is implied. Implied means ये पता है. हमें कहने की जरूरत नहीं है. We are agent of each other. We are acting. We are binding the firm. So all these acts have to be done even without expressed intention. Authority of the partner to bind the firm is the implied authority. Means this is the power that has been given to the partners under section 18 mutual agency that the partners are binding each other. However, the restrictions, the acts must be done. Now, this is how if a question comes related to the implied authority of partner, this is what you all have to write. Okay, Divyansh, I'll read your question after this topic. So it says the acts must be done for the usual scope of business. Again, that travel agent, for example, you can simply remember if the travel tickets were for personal use, then the firm is not liable. If it is for the business purpose, then the firm is liable. It must be done in the normal conduct of the business. If you have purchased the shoes for the selling in the business, then firm is liable. If you have purchased the same shoes brand for your daughter, for your husband, for your wife, for your personal use, then firm is not liable. Usual way of carrying the business depends upon the particular case, how you're doing that business. Acts must be done in the name of the firm, then only it is binding on the firm. Section 22 says, if I have purchased the shoes in the name of ABC Associate Shoe Business, then only the firm is liable. Not if I have purchased the shoes for my own personal use. A partner has the implied authority to bind concerning with the partnership business, which are done in the usual and not in the nature scope beyond the partnership. You must remember implied authority may differ in different kinds of business. हर business में implied authority अलग हो सकती है. Chartered accountants or partners, they may be in the audits. We are not doing taxation, so taxation is not within the scope of my authority. We are the partners only for the taxation work. Audit is not part of my scope of authority. Depends what is the implied authority, different in different. A partner in the form of solicitors. Solicitors means lawyers. They're borrowing and executing money. Execute promissory note without authority. Now, borrowing money is within the authority of the partners. Filing a case is within the authority, but case withdraw nahi kar sakte. Filing a case is within the authority. Liability admit nahi kar sakte. Compromise nahi kar sakte. Statutory restriction. Similarly, you can make the payments by check, but executing promissory note without authority is not allowed. You cannot execute promissory notes and bills of exchange in partnership. Okay, because in the name of firm, you cannot say I promise to pay rupees 20,000 in the name of ABC Associates. You cannot execute that without authority. You have to ask the other person. Other partners are not liable as it is not part of the ordinary business of the solicitor. Lawyer का business नहीं होता है to draw करना, accept करना bills of exchange. It is usual for one of the partners or bankers to draw and however, it may be usual for one of the partner of the firm and bankers. So bankers के लिए it may be a normal business, but solicitors का business का part नहीं है. Are you understanding? Your business is for sale and purchase of shoes. You are buying clothes. Firm is not liable. Your business is bank. You're a bank partner in a bank. Sale, purchase of negotiable instruments is your business. Then the partners can do. Solicitors, it is not your business. Then if you're doing it, it is outside the scope of authority. Is that clear, everyone? So if partnership is of general commercial nature, he may pledge or sell the partnership property, buy the goods, borrow the money, he can endorse. All these contains the implied authority. Okay? So these are the activities which the partner is allowed to do only if it is within the scope of his authority. Then only he can do. Not outside the scope of his authority. Now, extension and restriction of a partner's implied authority is dependent upon, can you settle the liabilities? Well, yes, partners can settle. Liability point now, Kavita, section 25, 26, 27. Wahan samjhe. How to pay off the liabilities is section 25, 26, 27. Here we are just talking about binding the firm. मेरे actions पे firm जिम्मेवार है या नहीं वो बताता है section 18 to 20. Two firms are having 12 partners combined by an agreement into one firm. Whether the following partnership is a two firms, yes, it is a partnership. Beta, what is your doubt in this? Two firms each having 12 partners combined by an agreement. So you cannot have a firm, a partner in another firm. Two separate firms having 12 partners, that is fine. Why? The maximum number of partners is 50 as per company's rules 2014. So 12 partners in one firm and 12 partners in another firm. They can be a separate partnership, but you cannot combine them into one firm. Okay? Is that clear, Divyansh? Because there is a statutory restriction that partnership cannot enter as a partner in another firm. Yes, firm cannot be a partner. Absolutely correct. Amalgamation of firms, Naina Verma. So Naina Verma, we have to go to CA final and then we learn about amalgamation of firms. You don't have to go into amalgamation of firms on a topic. Okay, it's your CA finals topic. Yes, Neil Kothari, you want to ask something, beta? Unmute yourself, Mr. Neil. You want to speak something? Okay. So a partner borrows 1,000 in the name of the firm, but in excess of his authority. Excess of authority means he's not allowed. Okay. And utilizes the same in paying off the debts of the firm. The fact that the firm has contracted debt suggests that it's a trading firm acting the authority of pay to borrow the money. Trading firm means हमारा business है, हम trade कर रहे हैं. I have borrowed in the name of the firm, but in excess of authority, but I'm using it to paying off the firm's debts only. Authority of pay to borrow the business. This implied authority may be restricted by an agreement. If the lender is unaware of this restriction, firm will be liable to repay the. If B is unaware, then he will. Now, example number 6 is exactly the example, simpler example that I've given you in my presentation related to the third party who is Mr. X. So here, Mr. X is Mr. B, and same principle you have to apply. If third party is aware of the restriction, then you cannot recover the money from the firm. If you are not aware of the restriction, then you can recover the money from the firm. Is that clear? And section 21 is very, very important. It's a small paragraph given over here. And 3 to 4 times examiner in ICAI module, ICAI examination has asked you a question on this. Can a partner act in an emergency? It is very simple. And we expect you to write this paragraph in that answer. A partner has the authority to do all the acts for protecting the firm from the loss, which would have been done by a person of ordinary prudence under similar circumstances, and such acts bind the firm. अब वो सेम एग्जाम्पल जो मैंने डे 1 में डे 2 में आपको समझाया था कि फायर अकर्ड इन द पार्टनरशिप फॉर्म एंड मिस्टर ए जम्प्ड इनटू द फायर टू सेव ऑल द फाइल्स and he suffered certain losses, firm should pay him. Yes, ma'am, it is the duty of the firm to indemnify any partner for the loss that he has suffered. Section 21, same words. Partner has the authority, point number 1. In an emergency, this was an act of emergency, fire occurred. To do all the acts, yes, he did all the acts for protecting the firm, yes. From any loss, 4th point, loss से बचाया, firm को बचाने की कोशिश करी, loss से बचाया, ऐसे बचाया जैसे कि वो अपने बिजनेस को बचाता. As a man of ordinary prudence means अगर मेरा बिजनेस खुद का होता तब भी मैं ऐसे ही एक्ट करता. Man of ordinary prudence means you're acting in the same way genuinely as you would have done in your own case. Then it is known as such an act is binding the firm, means firm has to pay the partner for whatever loss he has suffered. Section 21, everyone clear about this? Now let's beautifully do section 23, 24 and 25 from the study material. They are very small, section 23 and 24. Then we'll move to the liabilities. Effect of admission by a partner, section 23. Now here, children, he is not talking about admission of a partner. Admission of a partner is a separate section where the partner is joining the firm. Here we are talking about admit karna, means accept karna. You can write down here, we are talking about the acceptance given by a certain partner. Admission means acceptance. If one partner admits anything, it will be assumed that whole of the firm is aware of it. If one partner says yes, means A, B, C, all of them said yes. This is the meaning of the word admission. Divyansh Bhatti is again writing why study material tells enters into partnership on behalf of the firm. So that means, Divyansh, you have not heard my lecture clearly. Now, last time, listen to the answer to this question. Mr. Divyansh, listen. There are 8 points. Point number A, B, C, D, E, F, G, H. These are the points in which I have told you the firm is not allowed to do all these things. There is a statutory restriction on implied authority का हिंदी में मतलब होता है कि ये सब चीजें firm नहीं कर सकते. Now he has written, ma'am, I understood. So remember, so that first underlining line is important, bacha. Then only you understand what is written over the points. Okay, I'm glad you have understood. Good. Now, admission, now all the eyes and ears here, section 23. Let me see Ms. Kushal and others also, if they don't, Viran Gupta, everything is here now. Ms. Kaushal, Vishwas, Bhaskar, Aniket, yes, Mr. Sajib Das. Okay, good. All right. So, now you will first pay attention to the sections, and then after section 27, I will give you allow you the time to speak. Okay. Partners as agents can make the binding admissions, but only with relation to ordinary course of business. Binding admissions means जो भी पार्टनर ने बोला है वो सब फर्म ने कहा है ऐसा माना जाएगा. Admissions means acceptance or representation. Admission or a representative will not bind the firm if the authority is limited and the other party knows about the restriction. So I told you under section 20, if the other party is aware about the restriction, then it is not binding. Here it is speaking about admissions and representations, evidence against the firm This will affect the firm when tendered by third party, will not have the same effect in case of dispute between the parties. Now, what does it mean? Example under section 23 and section 24 will make the point more clearer to you. Admission का मीनिंग पता लग गया. It is not speaking about the admission of a partner. Admission by a partner means अगर एक partner ने कुछ representation दिए, कुछ कहा है, तो assume करा जाएगा कि firm is saying that thing. X and Y are partners dealing in spare parts of different brands of motorcycle bikes. Z purchases a spare part. So X and Y are partners. They are dealing in the spare parts of different brands. They are sale and purchase of brands of motorcycle bikes. They are doing. Z purchases a spare part for his Yamaha motorcycle after being told that the spare part is suitable for his motorcycle. He has been told that it is a suitable part and Z is purchased. X told him that this is a nice motorbike part. You can purchase it. It is fine for your motorbike. You can purchase it. That's fair. Y is ignorant about this transaction. And now the spare part turns out to be unsuitable and it is damaged. Tell me in the chat box, do you think that both of them will be held liable and why? Everyone has to answer this. Yes, excellent answers given by everyone. Because of mutual agency, excellent. Both of them will be liable. Because one partner says something, you cannot say that, Y cannot say that, no, I never said that, X is saying that, X should only be held liable. It's a mutual agency relationship. That's why both of the partners are held liable. And section 23 specifically tells you that one partner has made a representation means whole of the firm has made a representation. So both of them will be liable for the law. एक ने गलती करी तो सब जिम्मेवार है हिंदी में. ओके. सेक्शन 24. अब सेक्शन 24 says effect of notice to acting partner. If the acting partner has been told of something, अब वहां था गलती करी तो सबने करी, यहां है अगर एक को पता है तो सबको पता है. Notice means to tell. If one of the acting partner is aware, notice means मेरे knowledge में है. Notice means to have in my knowledge. So if it is in my knowledge that one of the partner knows about something, it will be considered as whole of the firm has knowledge about it. All right. But the notice must be actual and not constructive. It must be received by a working partner and not sleeping partner. Underline this line in your study material. Sleeping partner is not known to the outsiders. Why are you giving him a notice? How will he get a notice? Real partner, active partner should have got the notice, then only. So a legal notice is coming from the court. So if it has gone to the active partner, even one of the partner has received that notice, it will be assumed that whole of the firm is aware about it. But not to the sleeping partner and must be related to the firm's business. Then only it will be constituted as notice to the firm. PQR are partners for the sale and purchase of second-hand goods. R purchases second-hand car from S. In the course of dealings, he came to know that this is a stolen car and it actually belongs to X. A PQR, they are partners. They are into sale and purchase of second-hand business. And now R has purchased from S, but later on he came to know that it belongs to X and it was a stolen one. Now this awareness, this knowledge, which R has come to know now, will be considered that all the partners know about it. एक को पता लगा कि चोरी की गाड़ी है, X की है, तो that means सबको पता है. All the partners will be held liable to X, the real owner. Is that clear? Example number 8 is clear to everyone? Yes, Naina Verma, despite of the fact that they are not aware, then also he will be held liable because notice to one partner, because admission by one partner is construed to be the notice and the admission by all the partners. Ansupa, Naina Verma, Divyansh, Abdul, very good answers given by all of you. Anil, excellent. So that means you all are understanding it nicely. Very good. But the only exception lies in the case of fraud. Mark it important. Example 8 and 9 के बीच में ये line को important mark कर लो. Means अगर आप fraud कर रहे हो, cheat कर रहे हो, then you will be held liable to other partners also. A partner actively participates in the management of the business. So he's an active partner. He bought the goods and he knew that there is a defect in the goods. Now, this knowledge of defect will be considered as the knowledge of all the partners. However, other partners are not aware that there is a problem in the, they are not aware about this defect. But because A had, in league with the seller, conspired to conceal the defect, this rule will become inoperative. Then means he's doing a fraud. Now, what is he doing? A said, okay, fine. I will not tell the other partners, give me this defective material at a low price and we will sell it in the market. Other partners are innocent. They don't know that A is trying to cheat them. So here you are doing fraud. Here only that partner, Mr. A, will be held liable. This is the only exception where if fraud is involved, then only that partner is held liable. But where no fraud is involved, the awareness is there, knowledge is there, then whole of the firm will be held liable. Is that clear to all of you? Now let me do an example of section 25 to 27. Then I'll give you a small 5 minutes break so that you can read the section still here, and then we'll move to section 28 and 29. Liability of partners is joint and several. What is the meaning of joint and several? Joint means A, B, C are partners and the liability is 50,000. Jointly also we have to pay 50,000, or severally means individually, separately. Mr. A can also pay whole of 50,000. He can recover the balance from B and C, but either jointly partners can pay or individually. Severally bhi hoti hai inki, joint bhi hoti hai liability. Liability for a wrongful act of a partner. If any of the partner has acted in a wrong way, then whole of the firm is liable. However, other partners can recover the damages from that partner. So 30,000 loss done to the outsider, whole of the firm 10,000 had to be paid to the outsider because of the wrongful act. Wrongful means galat karna. Something wrong has been done by Mr. A. Whole of the firm will be held liable. But B and C can recover this balance 10,000 from Mr. A. Same as the case of fraud under section 24. If any wrongful act of fraud is done, that partner will individually be held liable. But for the outsider, you will have your liability to pay to them. And liability of the firm for misapplication by partners. Section 27. Section 27 is very interesting. There is a very interesting example given in the study material that partners are into the sale and purchase. They are into the taking care of the car parking lot area. I'll show you that example of section 27. It's a very amazing example given over here. It says A, B, and C are partners of the place of car parking. So there is an Elente mall in Chandigarh, and outside that mall, the car parking area is there, and A, B, C are the partners who are taking care that whatever cars are to be parked over here, they're partners in that business. Mr. P comes and he parks his car in that parking place. Now A said, this is a nice, kaun si chal rahi hai aajkal? Thar Rocks. This is the latest one, the latest model. So Thar Rocks was standing there, and A said that I am going to sell this car to a stranger. It's a nice model car, and we are the business partners in this place. Let's sell someone's car to a stranger. Can you do that? Is it your business car? Is it your partnership property? Not at all. The firm is liable for these acts of Mr. A. You cannot say that we have a funny partner, Mr. A, who is not in his senses. Whole of the firm will be held liable for this. You have done such a wrong action. Some customer on the trust of the car parking area stood his car and you sold his car only. आप ऐसा कर सकते हो? आप बिल्कुल नहीं कर सकते हो. Liability तो firm की हो गई, jail भी हो सकती है Mr. A को, and firm will also be liable. Firm को भी jail हो सकती है. So be very careful with whom are you doing your partnership. We cannot have the partners without having the knowledge about their mental strength. Okay. All of them will be knowledgeable. Yes, Abdul Shah, because knowledge of one of the partner is everyone's knowledge. Everyone has accepted it. Similarly, example of section 25 also we can do. Certain persons were found to be partners in a firm and there was an infringement on trademark by the firm. So there is a Maggie packet which comes from Nestle, and you said we are also into a partnership, and we have bought a Maggie packet which is the spelling of Nestle, Nestle. So you are trying to cheat. Infringement of a trademark means किसी के trademark को चुराना, copy करना. Whole of the firm will be held liable if you're doing any such kind of immaterial the damages that arose after the resolution. So any infringement you're doing, liability, all of the firm will be liable for this act. Wrongful act of the partner. One of the partners in coal mine acted as a manager was negligent of committing a shaft mine properly fenced. Now there is a coal mine जहाँ पे कोयले को माइनिंग करी जाती है, that area. Now this is a very little what do you say, this kind of activity involve proper fencing has to be done in such areas so that the person working in those shaft mines or machineries should not get hurt. Now one of the partners negligently means it was his wrongful act, although he did in the ordinary course of business within the authority, but he failed to put proper fencing and the other person got injured. Whole of the firm will be held liable. You cannot say that, you cannot put a blame that Mr. A, it was his responsibility, he has not done it. Whole of the firm. So that is the liability of the firm. Firm का मतलब ही ये होता है कि एक कोई भी गलती करेगा, everybody will be held liable. I give you 5 minutes. Section 23, 24, 25, 26, 27 are very important. Please read them. We are trying to go as slow as possible so that each and every word from the study material is covered. After this, we are going to complete section 28. We are already done partner by holding out. And after 5 minutes break, we will do section 29. Quickly go through the section 23. All right, students. I hope you have read all the points. All right. Shreya has a query in section 26. If a partner goes beyond his authority, then the specific partner. Yes, Shreya. So when you're going beyond your authority, then section 20 also needs to be seen. Okay. That if there is any restriction on your authority, then section 20 will come into application. Means you are not allowed to buy beyond 10,000, but still you are spending more than 10,000. Then you only are responsible depending upon whether third party is aware of that restriction or not. But if you are doing something which is within your authority in the ordinary course of business, then law says that yes, whole of the firm will be held liable, even if any wrongful act are done by one of the parties. Is that clear, children? Any more doubts? Anyone wants to ask anything? Okay, Shreya is clear on her doubt. Anybody else has any doubt? Nena Verma? Okay, that's fine. You have written it clear, ma'am. Good. All right. Now let's do a very interesting example related to unlimited liability of the partners. Liability of the partners is always unlimited. What is the meaning of the word unlimited means? They are not just limited to a particular contributions that they have made towards the capital. No, it's not like that. Whatever is the liability of the firm, everyone have to pay that. Yes, Vedant Gupta is asking something. Can we focus on statements except in case of fraud on the firm? So Vedant Gupta in section 24, that if you have committed a fraud, then you are responsible for that activity. Say you were trying to conceal the facts, you were hiding that there is a defect, you have in discussion with the supplier, you have concealed that fact, all these kind of things, that means the fraud is being committed by you, then you are only being held responsible. Okay, even if the firm has bared the loss, the firm can recover it from you. Is that correct? Clarified? There is another doubt. Okay, no, ma'am, no doubt. The liability is not limited. Ansupa says that it's unlimited. Very good. That's correct. Miss Kaushal, any doubts you have? Vedant Gupta, I hope your doubt is clear. Okay, let's move forward now. Now, three general partners, they invest 10,000 each. So 30,000 they have invested, new business they have started, but the business failed. And the liabilities amounts to rupees 90,000. Now, if A says, no, I to just got 10,000, I will only give you 10,000. Why should I pay you more? Can A say that? What will be the liability that they will have to pay? 30,000 is the contribution common stock capital that they are having. So they have paid 30,000 out of 90,000. How much liability is left now? 60,000? Everyone on the same page. Now, how will the 60,000 be contributed? Can A says that I will not pay anything. I got my capital 10,000. I will not pay. You cannot say that. Individually, you have to pay 10,000. Means your personal assets you will have to bring from the home if you don't have money in the business in order to pay off the liabilities, because that is the only drawback of partnership, that the liability of all the partners is unlimited. You have to pay off the liabilities, whatever business you have done. First, you try to settle the liabilities from the business that you have. Otherwise, the personal assets will become liable. Very good, Abdul, Ibrahim, Ansupa. Excellent answers, because it is unlimited. That's why everyone will have to pay it. Now, after section 27, they're showing me section 29. What was section 28, children? Anyone remembers? What was section 28? Excellent. Partner by holding out. We started our session today with the query on partner by holding out. So now let's move to section 29. That is partnership, transferor and transferee relationship. So rights of the transferee of a partner's interest. So it says if you want to introduce a new partner, it will result in the change in the nature of the firm. Therefore, it is mandatory to take the consent of all the partners. Now, is joining the firm and A and B are not agreeing to it. Only Mr. C has said yes. Can Mr. D join the firm? Can we introduce a partner where two partners are objecting that he should not join the firm? Can only by one partner saying, or maybe two of the partners saying, or say out of 50, 40 partners say yes, can they join? Can a new partner join the firm? Answer is no, ma'am. Absolutely correct. Why? Because unanimous consent, excellent. No new partner can join unless all the partners give their consent. All the partners means everyone should have agreed. Then only the new partner can join the firm. Failure to obtain the consent. Now, there are 10 partners. We did not ask the other 7 partners, and 3 partners agreed to join Mr. D. Then the other 7 partners can demand for dissolution. If you have not taken their consent, they can file a case against you in the court and ask for the dissolution of the firm. What is the meaning of the word dissolution, children? You are account student. You have been doing partnership in accounts also. What is the meaning of dissolution? You all know that. Winding up of the firm, closing of the firm. Very good. Anil, Pavan, S. Jeevan, Muthu Raja, Natasha. Word. Everyone knows about it. It's a winding up. Demand for the winding up of the firm. Divyansh, Anushka, Pavan, Prapreet. Good. Excellent answers. So, you can demand for dissolution. So 2 points. First point under section 29, no new partner can be introduced unless you have taken the consent of all the partners. And point number 2 says that if one of the partners also have not given the consent, he can demand for the dissolution of firm. Can we transfer the interest in partnership firm? Interest means assets or the profits of the firm. Now section 29 exclusively talks about trust in the, but first of all, what is the meaning of the word interest? Interest means profits. You're out of my own share of profit. Suppose we have profits 1:1:1:1. So 1/4 may say, I want to transfer certain profits to Mr. D. Or I want to transfer my assets of the firm to someone else. So interest means either the profits or the assets you're transferring to someone else. Then section 29 says, yes, with the consent of all the other partners, you can transfer. You may be transferred means you're allowed to transfer. It is not mandatory, but if you want to transfer your partnership interest to someone else, you can do it if everyone has consented for it. Section 29 subsection 1 tells you this new person, Mr. D, to whom Harleen ma'am has transferred his share of profit, will only receive his share of profits as declared by all the partners. Let's assume I have transferred 50% of my share of profits to Mr. D. So we have 4 partners equally sharing the profits. The profits were 40,000 for that year. So 10, 10, 10, 10. Barabar. How much profit I'm going to pay to Mr. D? 50% of my share. So 5,000 profit will be given to Mr. D. That is the transfer. Clear? Sapna Chaudhary, Anil, Ansupa, all of you given correct answers. Is that clear? 5,000 is the profits that will be given to Mr. D. All right. So now he will only receive the profits declared by partners. Means he 5,000 jo uska share banta hai, itna hi milega. Can Mr. D come and tell that I want to check the books of accounts? How did you conduct the business? Show me. Why I've got only 5,000? You're earning in crores and lakhs. Why I'm being given this much amount only? No, he cannot inspect the books of accounts. He cannot participate in the conduct of business. He has no interference. He's only required to see quietly. He will sit and get his share of profits that one of the partner, Harleen ma'am, is transferring her 50% share. He will only receive that share of profits as declared by the partners, but he cannot conduct the business and he cannot inspect the books of accounts. Is that clear? But if the firm gets dissolved, now this was the why you don't have any right, Pavan Kumar, because number one, it is with the law under section 29 subsection 1 has given him not any right while the business is in continuation, because you are only allowed to transfer your interest, but the other person is not admitted as a new partner. He is a transferee relationship. Transfer means जो transfer करता है, transferee means जिसके पास आपका share of profit जा रहा है. He is not joining your firm. Okay, section 29 exclusively talks about transferring your interest. When we talk about section 31, here the partner will be doing everything because the partner is joining the firm. But as of now, under section 29, you're only allowing the partner to transfer his assets or his share of profits. That's why he cannot interfere in the business. So to sum up, section 29(1) deals with the business in continuation while we are doing the business. But section 29(2) deals with when the business comes to an end, means when the firm gets dissolved, then transferee is entitled to all the assets of the original partner, and now he can also inspect the books of accounts. So when the firm gets closed, this Mr. D will get all the original assets of Harleen ma'am. The original partner was Harleen ma'am. So all his original assets will be given to Mr. D. And now Mr. D can interfere in the books of accounts and he can inspect the books also. Why? Because now he wants to say dissolution can happen either I am retiring the firm, I am leaving the firm, or the death of the transferring partner who has transferred his shares. So now the transferee will get all the assets and also he can inspect the books of accounts. So section 29, how we have to learn. It is a brief summary given in my notes. You can just learn it directly from here only. Partner cannot be admitted unless all the partners have consented. If you transfer your interest without obtaining the consent, the other partners can demand for dissolution. What is the meaning of interest? Transferring the shares or profits of the firm. In section 29, subsection 1, the rights are not to interfere in the business, not to conduct the business, not to inspect the books, only to get the profits which have been declared by all the partners. And section 29, Section 2 tells you in case of dissolution happened because of the reason or retirement or death of the transferring partner, then he has the right to all the assets of the original partner and also he can inspect the books of accounts. Yes, Divyansh, that is absolutely correct. You can file a suit for dissolution for the net assets, for your settlement of accounts, whatever you want. All right. Is that clear? Section 29. Any doubts in section 29, children? Because then we'll be moving ahead to section 30. I will give you a brief introduction of section 30, but section 30 is very, very huge. So we will cover all these balanced chapter in the next class also. So any doubts till section? Anyone wants to ask any doubts first? You can raise your hands and ask the doubts because then after that we'll be finishing. Ansupa says, no ma'am, no doubts. Everything is clear? Okay, Divyansh, I knew Divyansh would be having a doubt. Anybody else? All right, Divyansh, yes, please speak. Shreya says all clear. Anshika says all clear. Ahmed, Priyanshi, everybody's clear. Okay. Yes, Divyansh, you can speak, beta.
मैम वही वाला जो क्वेश्चन है वो समझ में नहीं आ रहा, जहाँ पे 2 फर्म्स थे जिसमें 12 पार्टनर थे. दे हैव मेड एन एग्रीमेंट टू फॉर्म सिंगल फर्म. उसी क्वेश्चन पे डाउट है मैम.
डाउट क्या है बेटा? देन दे फॉर्म अ सिंगल फर्म, देन व्हाट हैपेंड? व्हाट वाज द डाउट?
मैम फर्म जो है, फर्म एक पार्टनर नहीं बन सकती.
नहीं बन सकती बेटा.
तो इसमें 2 फर्म एक फर्म के पार्टनर कैसे बन गए?
So where it is written बेटा, it might be merging of the firms, amalgamation. Okay, both the firms are merging and forming one partnership, then it's fine. A firm cannot be a partner in the firm. Okay, you cannot have ABC Associates as a, suppose there are 3 partners under ABC Associates. So ABC Associates is a firm. Now you're opening a firm, D partner, E partner, F partner, and ABC Associates joining as a partner. No, this is not possible. Okay.
Okay.
All right. Anybody else has any doubts? Okay, I can't see any more hand raised. So shall we proceed ahead, children? Let us have a round of study material also. Anything from section 29, if we can do any example over here. So see, I told you under section 29, they have written section 31. We will discuss in detail when the partner is admitted. Here he is just joining for the transferring. So during the continuation, you cannot do these kind of things. After the firm is dissolved, he will receive his share of profits and all those assets which were entitled to the original partner. Now, section 30 tells about a very interesting thing. This little child sitting over here, a minor who is below 18 years of age. Pavan Kumar, you want to ask something? What you have not understood under section 27, you can speak and ask Pavan Kumar. Yes, Pavan. Pavan is saying, ma'am, section 27. You want me to explain from the study, Pavan? So section 27 simply tells you misapplication by a partner. Okay, Pavan, can you hear us now? Section 27 tells us about the misapplication by a partner means any of the partner, if he tries to misuses any of the assets of the firm. Here it has been misapplication of money by the partner. So it can be if money is being misappropriated, or the case where the partner is acting within his authority, he receives certain money and misapplies it. So you took the money, a client has paid you 10,000 and instead of putting it in the firm's books of accounts, you went to watch a movie. That means you've misapplied the firm's money. First of all, tell me, all of you, can you go and watch a movie out of the firm's money? You cannot, right? You can only watch the movie from your share of profits. You cannot take the firm's revenue home. So then that means money should have actually been kept in the custody of the firm, not taken home. So clause A is this. Clause B says where the property comes into existence and you have misapplied. So property means over here, the second example has been given. Example number 12 deals with section 27 clause B, which tells you that this car which was given was the property of the firm. It is the responsibility of the firm to take care of this car because they are into partnership business. People come and park their car. They have to take the responsibility and give the car back to the customer. But now you're misusing it. You're doing the wrong thing. You have sold the car to someone else. Instead, it is a kind of a fraud also that you have done. Whole of the firm will be held liable. If receipt of money is not within the scope, his receipt cannot be regarded and the other partners will not be held liable unless the money comes in their possession. So unless it has come into your possession means only when you have received it, then only you will be held liable, not others. Okay? Everyone clear about this now? Okay, thank you. Pavan Kumar says, thank you. He has understood. So good. Now, quickly tell me, children, can minor become a partner in the firm? This little small boy who is less than the age of 18 years, can he become a partner in my firm? So it says minor's contract is not valid because minor is not competent to enter into a contract. So all my dear students have studied Indian Contract Act. Can you tell me why the contract with minor is not valid? Can you tell me the name of the leading case law where it was held the contract with the minor is not valid? Think about minor's contract from Indian Contract Act and refer the case law. Mr. Soumil Arora says if we write section number wrong and the content is correct, then marks will... No, Soumil Arora, see, you might get marks, but please never write a wrong section. Why do you want to write a wrong section? If you don't recall a section, don't write it. It gives a wrong impression. Vedant Gupta, correct. He can enjoy the benefits. Vedant Gupta, why do you feel that it sounds unfair that the transferee can't inspect the books? He cannot inspect the books because he's not given the right under section 29 clause 1. Reason being, he's just a person who is enjoying the profits on behalf of the transferring partner who is giving him his share of profits. If he starts interfering in the books of accounts and business, then section 31 will become applicable. That means he will become a partner in that firm. Okay. All right. Hanji. No more doubts. Mohori Bibi something. Vedant Gupta, you don't remember the name of the case law? What is the meaning of something? And who else doesn't? Dharmodas Ghosh versus Mohori Bibi. Shriya, very good. Ansupa, Anshuka, Ibrahim, Amit. Minor can be admitted only with the consent of all partners. Okay. Mohori Bibi, Pavan Kumar has given the correct name. Abdul has given the correct name. Excellent children. Mohori Bibi versus Dharmodas Ghosh. That is the name in which it was decided that minor cannot be admitted as a partner. Any contract with minor is not valid. Then what is it? You should have written the word, children. Any contract with minor is void ab initio, means it's void from the very beginning. Now, why do we need to give this? Okay, I'll just explain you briefly, you know, why should we discuss the presentation? No, Anshuka, it's not void, it's void ab initio. What is the meaning of the word void ab initio? Means it's void from the very beginning. शुरू से ही उसकी उस contract की कोई बुनियाद नहीं है. क्योंकि minor के साथ you cannot make any kind of contract. So even in that specific case law, when you have read about it, that landlord has given mortgaged his land, taken money from him. So the court held that land will also be given back to the minor, and also the advance money that has been given, that was taken back by the minor. Because court says it is void ab initio. Minor ke saath aap contract kar hi nahi sakte ho. You cannot do any contract with the minor because he is not allowed to enter into a contract. Now, why we give the reference of this Contract Act and Indian Contract Act in the minor's admission under Section 30 of a partnership is because partnership has come out of the Indian Contract Act only. Here we are forming a contract between the partners, right? Here we are talking about the agreement. So that agreement is a contract between the partners. So only if all the other partners will allow, then a minor, a child can also be taken into a partnership, but he will only be allowed to enjoy the benefits of partnership. So in the next lecture, I'll tell you when till the age he's a minor, what will be his rights, what all rights and benefits he's getting, and what will be his liabilities. And after he turns from minor to major, even if one day is left for him to get of 18 years of age, he will be treated as a minor. मतलब अगर 17 years 11 months का है, 17 years 11 months and 29 days का है, then also he'll be treated as a minor till he turns the age of 18 years of age. But the moment he turns 18 years of age, he will be required to give a public notice within 6 months whether he wants to become a major in the firm or he wants to leave the firm and go. Why this happens? Because the rights and liabilities of the minor, as soon as become major, it changes. Now, children, any question related to case study base you get from section 29 or section 30, and these are favorite sections of examiner partnership में in sections में से generally question आता है. So you have to write it the way it is written in the law. So I expect all my students to come prepared from section 23 to 29 that we have done in today's class, and try doing a writing practice. Somebody was asking in the beginning, ma'am, how to make the notes. So you have your Bible, the study material in front of you. You have discussed the chapter with me. Sit down with your paper and pencils in hand. Try to write down section 23 in your own words. Read it twice, thrice from the study material. which है एक बार पढ़ने से समझने से learn नहीं होता है. You have to put in your efforts also. All right. So I hope, like all good students, you will revise whatever we have done, and you will definitely do the writing practice also. All right, all the best, all of you. I hope you don't have any doubts as of now, and we have completed the chapters as discussed. We'll be completing. It's okay, Pavan Kumar. Gradually, you will be able to learn it, everything. Okay, don't worry. Keep repeating it. Keep revising. All right. Thank you, Anil. Thank you, children. Thank you, all of you. God bless you all. Please do revise whatever we have discussed in today's class. All right, sir. We are done with the class.